Happy Friday night live, everybody. It's good to see you coming in. Let me know where you're coming in from as we get into the beginning. It's good to see all of you on this beautiful Friday night. Tonight, we have a lot on the docket. We have a weekly roundup, including Cardi B getting a big win in court, lawyers in the news, Michael Avenatti getting, prison time, Jen Shah's getting response from the government, and Trump taking on the tech bros some more. So those are our weekly roundup. Then we're going to get into all of the updates in the cases that we are tracking closely, Britney and Girardi, because there are updates in both of those cases that we need to talk about. But we're going to do our roundup first. First, we're going to do our roundup and cover all the things that you guys want to talk about. It's so good seeing everybody coming in from all over the world. I missed somebody in Finland. Hello, Finland. Good to see everybody. So let's keep pulling these up. I've got, what flavor is this? Watermelon, I think. I think this is watermelon. And hello to the Facebook crew. Yes, watermelon. I should have known. It's got green on the top. It makes it easy. So good to see everybody. How was your week? Are you well? Are we good? Are we tired? What's happening this week? It's a lot. Let's just crack it and get into it. We got to go. We got to get started. Replay crew, love you. Timestamps down below. Thanks for being here. Hey there. If we haven't met yet, I'm Emily D. Baker, the badass lawyer and everyone's favorite legal commentator. I'm the host of The Emily Show, and I break down the legal shit behind the news and pop culture stories we all want to talk about. I have been a licensed attorney for over 15 years, but this is not legal advice. I should warn you, I'm a big fan of the cursey words. This channel is where the law nerds unite to talk about facts, not fuckery. Hello, everybody. All right, I was going to do a poll for which order the topics go in, but I'm going to do the heavy ones first and the politically ones first before the entire chat gets full with people who don't act right. Because y'all, the law nerds that are here, you know what it is, and you know that we just talk about the facts. We leave aside all of the nonsense, and we've got two very polarizing figures up first, and that's just what we're going to talk about. And then, well, is Cardi B a polarizing figure? I mean, maybe, or maybe the person she's in her lawsuit with is, and Jen Shah is too. Damn it. Everybody's a little bit polarizing. I also have, if you hear binging, I have my email up. I never, ever leave my email open when I'm streaming, but I'm not confident that there aren't going to be new filings in the Britney case while we're live. So I have multiple different court alert systems. So I've got those pulled up just in case, literally on the phone too. I'm curious because stuff gets filed. There was stuff from court that didn't even populate until this morning from yesterday. So I want to make sure that we're on top of it before we wrap up here for the weekend. So all of that's pulled up. And we're just gonna go. We're just gonna go with the things. We're gonna do Trump first, y'all. Let's just talk about it first. Oh, also, don't forget to do the YouTube things. Yes, we hit 141K. I don't even know when it happened. I don't know. We binged. It's very exciting. I think we're actually close to 142. So we might bing on stream. And if we bing on stream, then we'll get to play it binged again, which will be very exciting. Let me pull up this Trump lawsuit so we can take a look at it directly from the lawyer's hot little fingers. That's how I see them typing, like this. This is how I pictured this one down in my head. Fuck you, Twitter. Fuck you, Twitter. Fuck you, Twitter. That's how I see this. That's how I see this all going down. So let's talk about this real quick. Trump did a press statement saying he was doing the things. And I was like, okay, well, we'll believe it when we see it. And here is sure as shit. It happened. Look, I know Trump is a polarizing figure. We're just talking about suing tech. And him aside, taking him out of it, the conversation around tech censorship is a conversation we need to continue to have. Whether this lawsuit isn't going to get very far because of Section 230, which generally prohibits lawsuits, like this one, or if we're going to get the courts looking at social media platforms as common carriers, more like a bus where you can't just look at somebody and be like, you get off. You can't just deny service. So this is looking at, are we reshaping these social media companies into common carriers, or are these social media companies allowed to say, you know what? You can't do that on our platform. Shoo. And that's really what the heart of this is in the most simple form, like in the most simple form. And in between stories, I will absolutely get to our super chats. Thank you for them. I see them. I will grab them after we get to each topic for sure. So this is literally Donald J. Trump versus Twitter's Jack Dorsey. Now, he says he's also suing Facebook. He says he's also suing the others. I don't know why that one didn't come up on Pacer. Let me look real quick. I'm going to look real quick and see if they were all filed as separate lawsuits, which is really annoying. But I guess the argument is they're not similarly situated. And I didn't even think that they wouldn't all be together. And so I didn't, I was like, wait, what? But I think they're all being filed separately. So let's take a look real quick and see if that is in fact the case. No, I want that one. Pacer's like, what are you doing? So he said in his press statement, he was suing all of the tech bros. Let's see if these were just filed separately, because it would make sense. The reason you would file them separately is so you don't have that weird joinder issue that you got in the original Triller case, where it was like, hey, you can't just sue everyone that you're mad at because you're big mad. You can't just do that. So let me take a look here. I don't see Trump versus Facebook filed. So I'll look for that next week and see. I don't see Trump versus Facebook filed. I see a bunch of the Facebook FTC stuff. So we're just going with the Twitter one. Perfect. Let's just do that. We're just doing the Twitter one. Yay. All right, let's put this back up. Trump versus Twitter and Jack Dorsey. Complaint for injunctive and declaratory relief. This is, I like that he put his title up here. Donald J. Trump, the 45th president of the United States. Like we don't know. Like we don't know. We're aware. I don't know if that is has to be there. Linda, I'm going to pronounce that wrong. Kurdos and American Conservative Union, individually and on behalf of the class. So they want this to be a class action. This is a class action complaint for First Amendment violation. We will see. So Trump is suing Twitter and Dorsey, both alleging that basically Twitter yeeted him off the platform, and that's a violation of his First Amendment right. But Twitter, again, is not a government actor. They go a long way in this complaint to try to argue that because Twitter has worked with the government, that they're like a quasi-government actor, which is a strange argument to me, but we'll see. They go on to say, using the unconstitutional authority delegated to them by Congress, defendants have mounted an aggressive campaign of prior restraint against a multitude of putative class members through censorship, flagging, shadow banning, etc., resulting from legislative coercion and collusion with federal actors. So they're trying to tie Twitter into a quasi-government actor for these First Amendment allegations. Defendants deplatformed plaintiff at the behest of and with cooperation from and with approval of Democrat lawmakers. I will be very interested in whether there is any evidence of that at all. Are there emails? Are there documents? Is this supposition? Is this just continuing on the narrative? I don't know. They go on to say, akin to forcing a round peg into a square hole, Twitter declared that specific Twitter posts of plaintiff had violated its self-composed Twitter rules. Well, they're allowed to have rules. Countless other Twitter users have not been as fortunate, with Twitter taking detrimental action against their accounts with no explanation whatsoever. That's just a throwaway sentence. If there's no explanation, again, Twitter's a private company. I don't know if this lawsuit's going to turn Twitter around and make it a government actor. Plaintiff respectfully asks this court to declare that Section 230 on its face is an unconstitutional delegation of authority and that defendants' actions directed at plaintiff and putative class members are a prior restraint on their First Amendment right to free speech. I just don't see how that's going to fly in court because the courts have declined to take this up and declare it unconstitutional in the past, and the new Florida restrictions on tech have not passed court scrutiny. So I just don't know if that's likely. Let's look at the causes of action here. We will cover this more in depth if y'all are interested in it. I want to see, because in the press statement, it was, we're suing everybody. This is the only one I was able to find when I started searching for these things. I imagine they'll all say relatively the same kind of causes of action with different facts that go to those causes of actions. Plaintiff is Trump. Class is all Twitter platform users. You all y'all are now class members who have resided in the United States between June 2018 and today. Oh, who had their Twitter account censored by defendants and were damaged. So not y'all. Mostly not y'all. A U.S. citizen and the American Conservative Union, a social welfare organization in the U.S. They say defendant Twitter and defendant Dorsey. We'll get into the statement of facts another night because really it's the causes of action that are the most interesting. We've seen basically what the statements of facts are. Trump said shit on Twitter. Twitter went, no, sir, and suspended account, and then was like, no, fuck this, and yeeted him off the platform. Like, that's the most basic summary of facts. But this is going to get into, these are not facts. These are the case law's argument. Defendant Dorsey. Oh, he gets one sentence. He's the co-founder of Twitter. Trump's use of Twitter, how they see him. Oh, I'm interested to see the Democratic legislatures coerce defendants to censor. What? How? Democratic legislators in Congress feared plaintiffs' skilled use of social media as a threat to their own reelection efforts. I mean, okay, that's like a supposition on a supposition of someone else's feelings. I don't know if you're going to be able to prove that in court, but the legislators exerted overt coercion using both words and actions. What words and what act? Like, where are the facts and the dates? Much like the Triller suit, I would like to see facts, specifically pled facts and dates, specific dates. Not only did Democratic legislators openly voice their displeasure with defendants for providing a platform to plaintiff, also their First Amendment rights, and class members, but they also spoke publicly of the steps they would take against defendants if defendants continued to provide a platform for the expression of views. But on what date, who said what? Because that's just a real blanket statement saying some people said some stuff about some things. Legislatures and in multiple instances, the current Vice President of the United States and the former First Lady of the United States made it increasingly clear that they wanted President Trump and the views he espoused to be banned from defendants' platform. On what dates? Who said what? You remember the Toddy Westbrook complaint when it was like, on this day, there was this video and this thing was said, and then on this day, there was this video and this thing was said? That's kind of what I'm asking for here. Dates and facts, specifically pled facts, not just conclusory statements that Michelle Obama made it clear that they wanted President Trump to be banned from Twitter, like a date and a fact or a tweet. I would take a screenshot of a tweet. With defendants shielded from liability for engaging in censorship by Section 230, the Democratic legislature then wielded that immunity, combined with the threats to revoke that immunity or otherwise regulate defendants, to use defendants as a tool to affect censorship and viewpoint discrimination against plaintiff and the putative class members. Examples. Below are just some examples of Democratic legislators threatening new regulations, antitrust breakup, and removal of Section 230 immunity for defendants and other social media platforms if Twitter did not censor views. That's interesting. Well, now we get some dates. Hey, look, dates of things being said and dates and things. Look, let's be honest. At Real Donald Trump's Twitter account should be suspended September 30th, 2019. I mean, Okay, but is that calling for him to be deplatformed, or I don't know, or is it calling for him to be paused? Pelosi on April 12th, 2019, but I do think that for the privilege of 230, there has to be a bigger sense of responsibility on it, and it is not out of the question that it could be removed. However, I see the point on this one, but however, it's not just Democratic lawmakers that have called for Section 230 to be removed. So how do you square the fact that legislatures on both sides of the aisle have called for 230 to be removed when that doesn't fit the narrative of this? Because that has happened on both sides of the aisle. Joe Biden in 2019, published in January 2020, said the idea that it's a tech company is that Section 230 should be revoked immediately, should be revoked, number one, for Dorsey and other platforms. There's no context to that, though. Like, that's an awkward sentence with no context, because it could be a statement of some are saying that if it's a tech company, Section 230 should just be revoked. But in context, that might be like, but that's not what we're doing. Interesting. They get into other Senate hearings. Bruce Reed said on December 2nd, it's long past time to hold social media companies accountable for what's published on their platforms. I mean, I think that echoes sentiments on both sides of the aisle too. Add Jack, time to do something about this tweet from Kamala Harris, but I want to know what the underlying tweet is. Now I want to know, and we won't know because it's probably a Trump tweet that's gone. Senator Markey, October 23rd, 2020. If the president goes on Facebook and encourages violence, that you will make sure your company's algorithms don't spread that content and you will immediately remove those messages, ? Senator, yes, incitement of violence is against our policy, and there are not exceptions to that, including for politicians, said Zuckerberg. But that doesn't have a lot to do with Dorsey, because those are Zuckerberg statements. This keeps going on. Oh, there's the Michelle Obama tweet, January 7th, 2021. Now is the time for Silicon Valley companies to stop enabling this monstrous behavior and go even further than they have already by permanently banning this man from their platforms. Well, that's a pretty clear call to deplatform him. However, does Michelle Obama have the power to wield over Twitter? I don't know about that. I think that's an expression of an opinion. Adam Schriff tweeted on May 5th, 2020, there's no constitutional protection for using social media to incite an insurrection. Trump is willing to do anything for himself, no matter the danger to our country. His big lies have cost America dearly, and until he stops, Twitter must ban him, which is to say forever. I mean, that's a pretty strong call, and that is a call post-election. But is that a threat? He had already been removed off the platform. So at least there are statements and specific calls that they are saying, these are threats against platforms, which is an interesting argument. Hey, all of these people are saying, if you don't do what we want you to do, they say, then we're going to remove Section 230 and allow you to be sued up one side and down the other. It's an interesting argument. I don't know if that'll fly, but it's an interesting argument. They talk about the coercive measures in different judicial hearings. I want to see what the actual causes of action are. Because this gets back into the election. Let's see. Is this about 230? In 1996, Congress passed the Communications Decency Act of 1996, which amended the Telecom Act of 1934. 1934. Right. The Telecom Act of 1934 doesn't apply well to Twitter. Was Section 230C intending to promote the growth and development of social media platform? Objection, not as stated, as well as to protect against transmission of obscene materials over the internet to children. Some of the original intent behind Section 230 was to make sure that if people were doing things on listservs, I mean, are we going to call listserv social media? I guess they are. They're social. But to protect like AT&T from getting sued because somebody at their home was doing stuff on a listserv, but they used AT&T to dial up to the internet. Remember the sound? The beep, boop, bop, bop, beep, boop. you know what I'm talking about, the internet dial-up sound. So to prevent the dial-up provider, AOL, from getting sued for shit somebody on their computer said from their home to somebody else somewhere else. It's like, oh, I don't like this. This was transmitted from AOL, so I'm going to sue AOL for this shit some other person said. So that, I mean, I guess those were the early day social media platforms. But it was like the listservs and stuff was really what was intended, that people be able to freely communicate ideas on the internet without the providers being afraid of getting sued for what those individuals said. It's congressional legislation commonly referred to simply as Section 230 or the Good Samaritan protection that Twitter relied on to constrain otherwise constitutionally permissible free speech on plaintiff and other putative class members. Section 230 provides treatment of publisher or speaker. No provider or user of an interactive computer service, listservs, shall be treated as the publisher or speaker of any information provided by another information content provider. So if I type something out on the Twitter's not a publisher that can be sued for shit I've said. They're not the speaker that's saying it. Twitter's not saying it. I'm the one saying it, the person behind the account. Where Twitter runs into a lot of issues with this is anyone can make anonymous accounts on Twitter and do all kinds of shit and say all kinds of shit. And it's really hard to figure out who is actually doing it and saying it, which makes things like cyber harassment so complex because Twitter doesn't bear any liability for that. Civil liability. No provider or user of an interactive computer service shall be held liable on account of any action voluntarily taken in good faith to restrict access or to access to or availability of material that the provider or user considers to be obscene, lewd, lascivious, filthy, excessively violent, harassing, or otherwise objectionable, whether or not such material is constitutionally protected. This is the moderation part of Section 230. Platforms are allowed to moderate their platform for things that they consider obscene, lewd, lascivious, filthy. Can you see the lean of this? Excessively violent, harassing, or otherwise objectionable. Otherwise objectionable is fairly broad. Otherwise objectionable is like, this isn't good. Otherwise objectionable is Wendy Williams today on her show. Though that, was it also harassing? You'll have to let me know. But otherwise objectionable is a fairly broad standard. And then Section B, any other action taken to enable or make available the information content providers or others the technical means to restrict access to material described in paragraph 1. So, you can't sue the person who made the algorithm to enforce these policies. You can't go and sue the company that helped develop the AI that then limits these things. And then they get into what Section 230 has done. According to Twitter's latest figures from the last quarter of 2020, the platform has 192 million daily active users. Raise your hand if you are one of those daily active users, except on Sundays. 55 million of Twitter's daily active users are in the US since 2018. Approximately 500 million tweets are sent out or twittered each day. Twitter reported 3.7 billion in annual profit. We're not shocked. Let's see what these causes of actions are. The Section 2. Look, Trump has been trying to end route Section 230, both as president and now through the courts. I don't know if the courts are going to be friendly to this conversation. So we will see. I think there are issues, but we will see. Receipts. Look, receipts. Causes of action. I would like to see the causes of action now. And the class yes, classes were deplatformed. Yes, people were deplatformed. Is this the actual? Oh, that Cardi B's in this too. Why is Cardi B in this too? Plaintiff Linda, listen, Linda, listen, Linda. Has a personal Twitter account, Wake Up with Linda, since 2018. I have no idea who this person is. She had 10,000 Twitter followers. Listen, Linda. She used Twitter to read news, push out content to large pharmaceutical companies, and push out content about large pharmaceutical companies and conservative ideals and connect with her community. She began noticing defendants were censoring her account. In 2019, her account was suspended for 12 hours for a post that said, "Shut up and twerk" to Cardi B. But was Cardi B offended? I need more context. Plaintiff also, is it considered harassing? Was she harassing Cardi B? I have questions about the context of that. Plaintiff has also experienced doxing by other Twitter account users. Well, welcome to Twitter. Plaintiff had reported the incidences multiple times to defendant, and nothing was done to stop the sharing of her personal information. I mean, I'm sure she's not alone in that experience. And then she was banned for promoting violence against or directly attack or threaten other people on the basis of race, ethnicity, national origin, sexual orientation, gender identity, religious affiliation, age, disability, or disease. Additionally, if we determine that the primary purpose of the account is to incite harm towards others on the basis of these categories, that account may be suspended with or without warning. So they told her why they were suspending it. She's asking, how is this hate speech? So that's her email back to Twitter. Count 1, First Amendment violation. There we go. Pursuant to Section 230, defendants are encouraged and immunized by Congress to censor constitutionally protected speech using the authority of Section 230. So they're saying Section 230 violates the First Amendment, but Twitter's not a government actor. So I don't know if this is the right vehicle to try to do this. Legally the right vehicle. Defendant censoring of plaintiff and banning plaintiff from Twitter's account while exercising his free speech as president was egregious violation of the First Amendment. I don't know if that's going to fly. Count 2, declaratory judgment of unconstitutionality of Section 230. I don't know if this court is going to want to say, yes, 230 is unconstitutional. And even if they do, if it will stand. Lower courts can declare things unconstitutional. They can do that. It would just be interesting to see if they find that 230 is unconstitutional because Twitter is a government actor. Defendants would not have deplatformed plaintiff or similarly situated class members, but for the immunity purportedly offered by 230. So the argument is that Twitter can't be sued directly by Trump because Section 230 says that they're allowed to moderate their platform. And because Twitter can't be sued because of Section 230, they would have thought twice about yeeting him off the platform if he could sue them directly, to which he is now suing them directly. And it will be interesting to see how long this survives, to see if the court says, but under Section 230, they're protected from this, which is why they're asking for 230 to be declared unconstitutional. I don't know if this is going to get very far. We'll see. And then they get into the class action allegations. They're going to start trying to bring in class members. They are the representative class members. I mean, I suppose at the time being, Trump has the money to do it. Let's look at the prayer for relief. An award for compensatory and punitive damages to plaintiff and the class in an amount to be determined at trial. An injunction, stop it, and declaratory judgment ordering Twitter to immediately reinstate the Twitter accounts of the class members. An injunction and declaratory judgment ordering Twitter to remove its warning labels and misclassification of all content of the plaintiff class and to desist from further warnings or classifications. Oh, so they want the whole warning system yeeted out too. A judgment declaring that sections 230 C1 and C2 of the Communications Decency Act are unconstitutional. Attorneys' fees and costs, punitive damages. I'm sure that there are going to be a whole lot of legal motions, and that at some point the court is going to probably dismiss this before it ever gets to trial based on those motions. But it will be interesting to see what happens. Look, I'm all for the courts evaluating Section 230 and really looking at it in a modern context. I don't know if this is the way to go about it, but I'm interested to see what happens. I mean, we'll follow it and see. I'm curious. Section 230 is one of the things that kind of prevents transparency on social media and prevents transparency on platforms like this one when decisions are made. I'm all for more transparency. I'm all for platforms having to be more transparent and allowing for free speech, but also platforms are businesses. So if you allow it to become a cesspool of hate speech, is anyone going to be on your platform? No. No. They aren't. I mean, unless that's what the platform, unless it's Kiwi Farms, unless that's what the platform's for, right? But on these major platforms that use massive advertisers, if if that's what a platform became, advertisers would leave. And so that's not in the company's best interest, and they have the right to choose to associate. So this is going to be interesting to see. I'm curious. And I think the problem with these legal conversations is once Trump is involved, it's hard to have the legal conversation that's deeper. We're going to keep having the legal conversations that's deeper about whether the law that they enacted in 1996 still makes sense today for the way social media acts. And that is a really valid conversation to have. We're going to talk about the First Amendment more. I will talk about this case a little bit more in depth when we talk about the First Amendment and some other censorship that came up that we're supposed to talk about Tuesday. And then everything went off the rails with Britney Spears stuff and we couldn't do it. So let's sweep the super chats and then get into our next topic. Thank you all for your kindness and patience while we talk about polarizing figures in the news in a kind and compassionate way. I appreciate you for it. You are the best. Law nerds, I love you. Matthew, hello, friend. Good to see you. Congratulations on the new job. Thank you. Thank you. Congratulations. Amanda Page, thank you for the congratulations. Lori Stack, don't the courts know we need info because we got to talk? I mean, they're not on our schedule. But if they were, which is why I'm getting email notifications about stuff, which is always interesting to me. So, all right. Question, how is Trump getting around 230? We don't know yet, Heather. The court might say, you want us to find 230 unconstitutional, but you can't bring this lawsuit because of 230. That might very well be exactly what happens. That might very well be what happens in this case, and they just toss it right out. So we'll see. I'm curious. I want to make sure I didn't miss any other super chats, but I need to go because stuff has already scrolled past. So I'm going to go back because otherwise they will go so far that I won't get to chalk back up with them. Taz13, thank you for the super sticker. Zanaku Fox, currently 2 a.m. in Sweden, and having you accompany me to work makes me less mad about my shift times. Well, thank you so much. Enjoy your shift. We're here all night. JC said Trump's suit saying he's a skilled user of social media made me instantly picture the Kafafi tweet, and I mean, it's fair. He's like, they were afraid of my Twitter prowess, is how I read that. Cat B2 said the dangerous thing about this situation, taking Trump out of the context, is that there is a basis in information because comments or facts are being censored. Then a group of people are the ones who dictate the truth. I think we can talk about censorship on social media because it's a bigger issue than just Trump. I think censorship on social is a bigger thing. When scientific articles are getting censored, it's a bigger issue. Laura Darby, thank you for the super chat. I appreciate it. Bree said it was my birthday this week. Love the channel and my law nerds. Happy birthday to you. All right, let's get into our next one. You guys, there's over 3,000 of us here on the YouTube, so don't forget to do the YouTubey things because it's much appreciated. We're going to get into our next story once I find my notes again and tell you what the next story is. What did I say we were doing next? Lawyers in the news. We're doing lawyers in the news next. That's what we're doing. That's what's happening. Lawyers in the news. I don't know why I want to yell it like that. I just feel like that's what it deserves. Like lawyers in the news. The same way I feel like weekly roundup is like roundup. I don't know. That's how things happen in my head. We're going to talk about a disgraced former celebrity lawyer, Trump hater, Michael Avenatti, who just got sentenced to 2.5 years in prison for trying to extort Nike out of $25 million. He also represented Stormy Daniels in the Stormy Daniels payoff thing, but then Stormy Daniels is suing him in New York, and he's going to be facing trial for that because she's alleging he stole her book advance of like $300,000, which, you know, if true, big problem. There's also 2 cases still pending against him in California for clients saying that he defrauded them out of their settlement funds. So weird that there's a lot of that going around. This is not something that was even on my radar as a DA because we just like put our heads down and did our jobs. And this amount of shady shit going on over in the world of civil law is so fucking wild to me. And then, so we've got a $300,000 embezzlement trial coming in New York, and then 2 defrauding clients out of settlement cases coming in California. And this, trying to extort Nike for $25 million, he's going to prison for. So Mr. Avenatti got 2.5 years. The thing is, though, his sentencing guideline ranges were not 2.5 years. He had a guideline range between 9 and 11 years in prison. So it was, again, like the Allison Mack sentencing, quite a downward departure for me. I'm like, but you tried to extort Nike for $25 million, hijacking your client's claim. So the judge in the case said that Avenatti's conduct was outrageous. So outrageous that he only got 2.5 years. Like, when they use such strong language and then don't follow through with the prison sentence, it always feels a little anticlimactic to me. He hijacked his client's claims and used those claims to further his own agenda, which was to extort millions of dollars from Nike for himself. That's some shady ass shit right there. He is due to report to prison on September 15th. Yes, this is what happens in the federal system. Like, you get sentenced to prison, you go to trial, and then you like walk out of the courtroom and get to go home and take a bath and figure out what you're going to do between now and when you're sentenced. This happens in quite a lot of federal cases. It's so weird to me because that's not how that happens in criminal court, in the state courts. Normally it's like you get sentenced to prison and you stand up, and then the bailiff puts your hands behind your back and walks you back into custody and away to prison or jail you go, depending on how long you're sentenced for. But this is like, no, go home, put your bills on auto pay. We'll see you back here in September. It's so strange to me. The judge denied Nike's bid for $1 million restitution for now. Prosecutors claimed that he used his client, Gary Franklin, the claim his client made about corruption, and demanded a $1.5 million settlement of about $15 million to $25 million for Avenatti. And they say fellow celebrity attorney Mark Garagos to conduct an internal investigation into the athletic apparel company. So the way this went down, it was like, hey, my client's saying this and you need an investigation. So if you settle with my client for this amount and then hire me to do this work, we'll just go away after that. So it'll be fine. This says that Avenatti never informed Franklin of his side ask for an internal investigation of Nike that he was going to get paid for, which is not okay. They did a 2.5-week trial or 2-week trial. He was found guilty in February 2020. I know a lot of you were following along with that. He told the court, "Your Honor, I have learned that all of the fame, notoriety, and money in the world are meaningless. TV and Twitter mean nothing." Well, TV and Twitter meant a lot because you put your life and your license on the line to be all over TV saying that these claims were bullshit, that you didn't do anything wrong, and that Nike is in fact the problem. That's not what the AUSAs proved to a jury, though. The sentencing memorandum said essentially that his epic fall from grace was like punishment enough. Like, he's embarrassed and that's enough. No. Extortion. Extortion. Though this will get piled onto, I suspect, in the following cases. Like, if he's convicted of those other cases, there will be additional time and potentially additional money that he owes to others. The judge also decried the horrific conditions Avenatti endured while incarcerated before trial for approximately 100 days at the MCC. Oh, okay. It was hard for you. It's hard to believe that they could occur in the United States of America, the judge said. So I don't know a lot about what happened to him in custody. I wasn't following along, but it factored into this sentencing, it sounds like. But the prosecutor told the judge that this case is about taking advantage of people and an abuse of power and trust, which is what it all boils down to. So, he went from being the actor all over television because of the Stormy Daniels case to going to prison. Interesting, isn't it? Interesting that the fame-seeking of the plaintiff's bar are finding themselves not in fame at the moment, but in court and being discussed here in Lawyers in the News. Do you guys think the sentence is too low? I can do a poll. Hold on. I'm going to do a poll because he was facing, those of you that have been following this story, what did I say? He was facing 9 to 11 years in prison was the recommended sentencing guidelines. I can do a poll. Hold on. I can do it. I didn't set it up beforehand, but I should have. But I didn't because I forgot to. Let's be honest about what it is. I have to have the other chat open. It's a lot to manage. I have to have the other chat open so I can put a poll up. Okay. Is 2.5 years. Sorry, everybody on Facebook. The polls are on the YouTube. And I enjoy participating in them. So is 2.5 years too low? Is the poll? It's up now for those of you playing along at home on the YouTubes. And at the end of the next story, I will stop this and then we will go from there. Next story, we are going to talk. Do we go to Cardi B? Do we go to Jen Shah? Do we go to Cardi B? Do we go to Jen Shah? I think we go to Cardi B and then do Jen Shah and Erica Girardi together because housewives, and then we will cover Britney and hope that nothing else pops off. I'm going to actually check and make sure nothing else has popped off. Hopefully it's a quiet Friday night. You guys are like cardio. Let's do it. All right. Cardi, Jen Shah, Erica Girardi, Britney. Let's go. All right. Let me pull up the court ruling. Cardi B had a pretty big win in court, and we're going to talk about that. We have not talked about this case. We have been covering so many other things, but Cardi B has her own defamation suit going on involving YouTuber Tasha K. So we've got like the side thing going on with this Cardi B Tasha K case, and it has been heating up in court and is getting ready to go to trial. So I'm going to give a brief road so far, and then we're going to talk about this latest court ruling and what it means, because it's kind of a big deal. It was a win for Cardi B for sure. So let's talk about that. Cardi B. It's so funny because all the articles on this, most of them do not say Tasha K's name. Most of them say Cardi B sues YouTuber or Cardi B sues YouTube gossip blogger for slander. On Thursday this week, as part of a summary judgment motion, Cardi B tried to get the 2 counterclaims by Tasha K kicked out of court, and the court agreed. A motion for summary judgment means that the court looks at the facts presented and the evidence presented, and then on those facts says, yes, there's enough to go forward, or no, there's not enough to go forward. So Cardi B sued for essentially defamation. Tasha K countersued, and we're going to get into that in a minute. So Cardi B sued. Tasha K said, yeah, but you did this shit. And so there's these 2 suits going on. Then they did the motions for summary judgment. The defamation survived to go forward to trial, and the counterclaims from Tasha K suing Cardi B all got dropped. And so it will just go forward on the defamation stuff. So Tasha K was sued by Cardi B in March 2019 after posting at least 38 videos referencing the singer, claiming that she was threatened by the celebrity's fans, including a purported gang member, and had to move house during a high-risk pregnancy. The judge said she failed to produce any evidence that Cardi B threatened her or made her believe she was going to be harmed. We'll get to the ruling in a minute. And the ruling does lay out a lot of what is going on with the case. The court did not throw out the defamation and stuff like that. So let's see what else. Tasha K posted at least 38 videos referencing Cardi B between September 2018 and March 2019 and was sued over it, despite the singer's repeated requests at that time for her to stop. So again, asking a YouTube channel, take it down, stop talking about me. I'm sure it was closer to the get your name out of my mouth and the cease and desist variety of things. And then it continued moving forward. So from that lawsuit, we are now getting ready to move towards trial. The court said, although plaintiff vehemently denies the information contained in these statements, Tasha K has represented to the court through video evidence that plaintiff has at least admitted to being a prostitute and to her use of drugs, the judge says. As to the other assertions, so the other potentially defamatory statements, such as claiming that the plaintiff has herpes, Tasha K allegedly saw a photo the plaintiff posted online in which the plaintiff had visible cold sores. And that is what this case is over. It's kind of Gabby Hanna, Trisha Paytas-esque, where they are now arguing over whether or not someone has herpes, and that being the defamatory statement. So, the judge said there are some facts suggesting that Tasha K may have posted and published statements without knowing whether the information was true, the judge said. Thus, a reasonable jury could determine that Tasha K acted with actual malice. So the judge is saying there is enough here to move forward on a defamation claim. You can't just throw it out. The judge set a September 10th trial date after blasting Tasha K's attorneys as unprofessional during the April summary judgment hearing, in which he encouraged the defense team to try to settle the case. This is why summary judgment motions can be so damaging, because the judge looks at all the evidence and the judge can look at your attorneys and be like, so you need to settle this because you're not going to win. And that is, based on these reportings, what it sounds like was the takeaway when they looked at the defense attorneys and went, there's enough here to go to trial, and this is going to be a problem for you. Summary judgment motions are and can be very damaging to a case. The attorney for Cardi B said Friday, today, our client is looking forward to prevailing in this action and holding Tasha K accountable for the vile and defamatory statements that she has made and continues to make. Counsel for Tasha K did not respond to the request for comment. Let's get into what this ruling says. We're going to go through just a little bit of this case. It's interesting stuff because now we actually have the court saying, these are the facts that I find. So a court is saying, these are facts. When the court looks at your attorneys and go, you're going to want to settle. Imagine what that does. We don't have to imagine. I can just tell you what that does because I've experienced that. I was going to say, imagine where Cardi B's attorneys go with that. Cardi B's attorneys turn around to their client and go, oh, did you hear the court telling them to settle because they're likely to lose? That's where we're at going into trial. So it definitely bolsters one side and can be kind of demoralizing to the other side, though it depends on personality. Some personalities would be like, the judge doesn't know shit. We're going to keep moving on. A jury's going to see it different. Like a jury will hear me differently. So some people will just say, hey, whatever, we're moving forward. Let's go ahead and get into this. All right. Order. This matter is before the court. This is the court's order. So this is the writing of the court breaking it all down. I am going to be calling everyone by their internet common vernacular. I am not going to try to slaughter Cardi B's name because I will get it wrong. I also am just going to call Tasha K, but it is Tasha K and her company that she operates her YouTube channel through. So this matter is before the court on plaintiff's motion for summary judgment. Plaintiff Cardi B. The court grants in part and denies in part the motion for summary judgment. We'll get into that. This is a defamation action brought on behalf of plaintiff Cardi B. For statements allegedly made by Tasha K. Defendant, they call her defendant Kibi. I might be pronouncing that wrong. If I do, no disrespect is made. That's just me not being able to pronounce things and never hearing Tasha K referred to by anything other than Tasha K. Plaintiff is a citizen of the state of California and is a Grammy award-winning musical artist, songwriter, and television personality, professionally known as Cardi B. Plaintiff has a YouTube channel, Plaintiff Cardi B, with approximately 17 million subscribers. Do you think Cardi B ever got her gold play button? Like, do you think Cardi gives a shit? Do you think at 1 million subscribers, Cardi was like, I want my gold play button? I don't know. Would she even apply for it? Does she even care? I don't know. I'm just curious. These are the things I want to know as we move forward. I like that they're just laying out Cardi's like like stats. This is who this is. She has 17 million subscribers, a Twitter account with 18 million followers, an Instagram account with 94 million followers. Defendant Tasha K is a citizen of the state of Georgia. Defendant is an entertainment and celebrity news blogger who produces, hosts, and publishes her video on YouTube, a YouTube channel entitled Unwind with Tasha K, Document 79. So these are all the sites to where the evidence came in. In the world of summary judgment, and as a former research attorney, motions for summary judgment, one of the things I spent the most time on, they could come with boxes of evidence and hearings. So when you see these little symbols, the little paragraph symbols, this is showing where these are coming from, because these are all facts that are cited back to other documents. So her YouTube channel has approximately 939,000 subscribers. She calls her site a drama-based blog with the 4/23/19 video so they cited back to her video. The 4/23/19 video at 17:30. YouTube. Defendant Kibi Studios is a Georgia LLC owned by Tasha K. Plaintiff claims it was formed as an alter ego or business conduit for the activities. What a lot of YouTubers do and should do is have a business entity that they run their professional organizations through. So yes, all. On September 19th, 18, Tasha K published a video on her YouTube channel of an interview she conducted with Stormy Jones. Stormy Jones was a former defendant in this matter. The claim against Jones was terminated on November 11th, 2020. I wonder why. We'll go look another day. The interview claimed to reveal information about plaintiff and was the beginning of events culminating in this case. In the 16 months preceding the filing of this lawsuit, gosh, every time you see a similarity to the KJ Toddy Westbrook case, raise your hand. No, don't. Just in your mind, you're like, yes. In the 16 months preceding this filing of the lawsuit, defendants uploaded at least 38 videos referencing plaintiff, a timeline of videos and alleged defamatory statement. Look, the court has laid it out for us so nicely. This reads a lot like the Toddy filing. On 9/2/18, the 9/2/18 video contains the statement that plaintiff prostituted for a living. The Jones video posted on Instagram Live by Stormy Jones. Jones claims to have known plaintiff before her musical career and to have worked and lived with her in New York. Jones currently promotes herself and her entertainment endeavors through social media, through Instagram, and has approximately 26.6 thousand followers. Jones made the statement that plaintiff got herpes. Jones stated, referring to plaintiff, I guess they were supposed to have sex, exchange sex for money. So again, references to illegal exchanges of money. Instagram comment. Shortly after Jones released the Jones video on or about September 13th, 2018, Jones posted a comment on her Instagram account to third parties that said plaintiff is just a Grammy-nominated prostitute running around spreading her herpes. Well, yikes. I think it's interesting that the defense is like, there's some evidence that might have happened in the past, so maybe that's not defamatory. Because again, truth means it's not defamatory. 9/19/18 video. Defendant Tasha K recorded and published a video of herself interviewing Jones regarding the Jones video on YouTube entitled Exclusive. Cardi B's ex-friend alleges Cardi B kept a huge box filled with monostat and reveals more. But what else was said? Is the fact that she has a box of monostat defamatory? I don't think. Okay. I have questions about that one. That video has garnered over 4 million views. There must have been other statements in that video. 9/19/18. But maybe there weren't. Plaintiff said, there we go. Plaintiff sent a cease and desist letter to defendants demanding the removal of the 9/19/18 video. Yeah. Of course there is. Of course there's a cease and desist. 9/21/18. Defendant published a second video entitled Actual Proof Cardi B Knew Her Ex-Roommate Drake. Funky Geneva versus Tamir, Beyonce Black Magic, where she stated that everything said in the prior video was true. She definitely doubled down then. She got a cease and desist and she's like, no, that's definitely true. You gotta appreciate the just chutzpah that we go out there with. Defendant claims that everything that we said, that everything that Jones said was accurate and that Jones was the source. Having a source in some some areas having a source can offer some protection. We saw that being an element of the settlement in the Toddy Westbrook case, that, there was a source for some of those statements, and then information was exchanged about those sources. But not always if they find that you knew that the statements were false, you knew that the source was false, and you continue to repeat them. Yes, for the original statement, it might not be a problem, but then after that, it might not be. That's just an aside, not with relation to this case, but just as a general commentary on defamation. 12/18/18, on December 18/18, defendant published a video on YouTube entitled Tasha K responds to Cardi B. I imagine it's a typo in the title of the video because it says defamation suit and Offset's dad calling out Cardi B and more. No shade on a typo. I do that shit all the time. 2018-18, and this is probably not a lawyer typo. I'll shade them a little bit more, even though I'm a lawyer with typos. Anyway, video contains the statement, plaintiff F's herself with bottles of beers on effing stripper stages. I mean, okay. 12/18/18 Facebook post. Defendant published a post on Facebook referring to plaintiff as Herpes B. I'm sorry. It's just, this is in a lawsuit. This is in a lawsuit. I mean, she definitely doubled down all the way down. She doubled just all the way down. All the way. Just whoop. All the way in. She just went in. Just went in. Okay. On January 4th, 2019, defendant published a video on YouTube entitled Exclusive, Cardi's Cousin Angry. Diddy and Casey, Tony and Birdman, Tiffany Haddish, R. Kelly, and more. The video contains the statement that plaintiff was a prostitute. We already know from the court's above statements in the article I read that some of those claims they're not finding to be defamatory. On or around January 25th, 2019, defendant tweeted that plaintiff had herpes. I mean, this just keeps going. 2/28/19, plaintiff sent a demand for retraction and repudiation of defamatory statements. So after the cease and desist, it is, I demand you retract this and I demand you apologize. Kind of like what's going on with Heather Dubrow and Kelly Dodd, where Heather demanded, it seemed through a lawyer letter, that Kelly Dodd apologized for saying that she got COVID from Heather Dubrow's son, kind of like that. I demand that you retract the statement and tell people that I don't have herpes. This is just a lot of conversation about the herp. I will please remind me after this to tell you about the judge I had that every time he would sentence somebody would refer to strike offenses as herpes. Like, we have to get into that story about court. We have to. Defendants temporarily unlisted or took down the 9/19/21 and 9/21/19 videos in March. On March 25th. Then on March 26th, relisted and re-uploaded the videos. I wonder what happened in that time frame that you would take them down or unlist them and then be like, nah, fuck it. I said what I said. I'm curious. On April 23rd, 2019, defendant published a YouTube video entitled Tasha K responds to Cardi B's #mute black blogs agenda. Cardi calls Shade Room owner a water. Okay. What? What? Like, what in the fuck is happening? The 423 video contains a statement that plaintiff, okay, back to the beer bottles, stuck beer bottles up her genitals. She actually took beer bottles from pedestrians. This is on video. She took beer bottles from the pedestrians, stuck it up her, I bet you the video doesn't say genitals, drank the beer bottle and gave it back to him. If it's on video, it's not defamatory. For everyone just coming in wondering where the Britney stuff is, we'll get there. We'll get there. Okay. That's oddly specific, but if it's not true, is it damaging? I mean, is that damaging to Cardi B's reputation? Here's the thing. Cardi B has, now the herpes aside, with some of this other stuff, Cardi B has a larger than life, outlandish personality and persona. She has highly sexual songs, highly sexual performances. She owns it. So some of this stuff, I'm like, but is it reputationally damaging or does it track? Because then it's not going to be defamatory because it's not going to really hurt your reputation. You still have to show that this stuff hurts reputation. The thing is with a lot of defamation statements and defamatory statements made in videos, you only need to win one to be like, I won. So it only takes one. On April 25th, 2019, a defendant published a recording of a phone call that Tasha K had with another YouTuber named Lovely T.I. or Lovely T. It's probably Lovely T. Exclusive Tasha K leaks private call proving Lovely T. Tasha K planned Stormy interview. Okay. In the Lovely T call, defendant states that Jones told some truths and she didn't tell all truths. Oh, I like that she just left it hanging there. Defendant Tasha K states, here's my thing. All of these strippers are lying, referring to Jones, plaintiff, and a third party. On July 19th, but then again, Cardi B is known to have been a stripper. There's no shade in that. So that's probably not reputationally damaging. These would have to be the statements in the complaint. But again, we get back to, are these actually defamatory statements? 7/19/19, a video contains a statement the plaintiff engaged in prostitution. November 18th, 2019, the video contains a statement that plaintiff engaged in prostitution. 12/30/19, video contains a statement that plaintiff was sitting on beer bottles. She was taking pedestrians' beer bottles. They were drinking and they could have some of the cold sores. There was a video posted on April 20th called This Is Why I Can't Work. A video contains a statement the plaintiff has herpes. So this is just reiterating how much this statement was made. September 18th, the video contains statement that plaintiff was a prostitute, plaintiff has HPV, and plaintiff committed infidelity, which can be reputationally damaging. September 21st, 2020, video contains a statement the plaintiff was a prostitute and plaintiff engaged in adultery. October 2, 2020, plaintiff sent an additional demand for retraction and repudiation. No, take it back. We're going to sue you. Demanding a retraction and repudiation. They filed the complaint on March 21st, 2019 for slander per se, slander. That's spoken defamation, libel per se, written, comments on the Twitter and the Facebooks, and then false light, which is, we've talked about a million times, but painting somebody in a false light. Then there was a First Amendment complaint for intentional infliction of emotional distress and sought punitive damages and attorney's fees because those can attach to this IIED claim. We saw that in the Toddy Westbrook case too. Plaintiff denies the truth of any statements regarding cocaine use, herpes outbreaks, prostitution, among other statements outlined above. Plaintiff also asserts the defendant was aware of the probable falsity of the statements at the time she published them. The thing is with the cease and desist, after the cease and desist, you know that they're saying the statements are false, which puts it in an interesting light because it's then statements made after that came. Do you know that they're saying these statements are false? So are you now on notice and continued false statements could be malicious? There's an argument to be made there, which is why when you get cease and desist, or if you get cease and desist, you have to talk to lawyers to make sure. Because Tasha K doubled the fuck down, but she might be like, you know what? But did I lie? And if that's her defense, that's a defense to defamation. So defendant's counterclaims. Defendant alleges that she's been receiving threats on her social media accounts or began in December 2018. Thirsty. Including use of derogatory names and references to gang member connections. She claims to have received those threatening messages on social media and calls on her cell phone from people directed to do so by plaintiffs. So she's alleging that Cardi sent, I don't know what Cardi B's fans are called, but sent the fans to her. This includes Cardi B's fans and Schemo, who defendant claims is closely connected to plaintiff and a member of a violent gang. Defendant also claims that plaintiff ranted about her on social media, including Instagram live videos, and responded to fans who also made remarks about her. As a result, defendant claims that she contacted the FBI about the alleged threats out of fear for her safety. She contends that she experienced an increase in her stress, anxiety, and depression during this time, and she was also experiencing a high-risk pregnancy and was forced to relocate her family. Based on this information, she filed a counterclaim. Remember, Cardi B sued, and within that same lawsuit, Tasha K then sued Cardi B. So then you've got all the suing. Defendant, based on this information, defendant filed a counterclaim on May 8th, 2019, amended the counterclaim on July 7th, 2019, answered plaintiff's second amended complaint, and filed their second amended counterclaims on December 13th, 2020. Defendant's counterclaims are of assault, intentional infliction of emotional distress, asking for punitive damages, and expenses for litigation and attorney's fees. Plaintiff filed her motion for summary judgment on December 30th, 2020, in which she seeks judgment on a matter of law on her defamation per se claim count 1, her demand for injunctive relief, as well as her IID claim. Plaintiff also seeks summary judgment on all of defendant's counterclaims. So what the court said is that all the counterclaims are thrown out. So Tasha K's lawsuit against Cardi B is thrown out, but they're not deciding as a matter of law that Tasha K committed defamation per se. That stuff is going to trial. They talk about the legal standard and that summary judgment's appropriate when there's no genuine dispute as to a material fact and the movement is entitled to judgment as a matter of law. Like when everybody agrees to the facts, it's like, okay, well, this is what happened. My side says it's not illegal. Your side says it is illegal. We'll throw it up and let the judge decide before it goes to a jury. That's essentially a summary judgment motion. And then they get into the burden. They get into the plaintiff's claims, defamation per se. Plaintiff bases her slander and slander per se claims on statements, including that she was a prostitute, she used cocaine, she had and still has herpes. Well, that she has a herpes outbreak on her mouth. That's oddly specific. That she has HPV, that she engaged in a debasing act with a beer bottle. I appreciate the court refining that statement, and that the plaintiff committed infidelity. Plaintiff also claims that she did not make reasonable attempts to verify the false and defamatory statements before publishing the videos and therefore acted recklessly. She moves for summary judgment. They talk about defamation under Georgia law, which is not dissimilar to defamation elsewhere. In this case, there is no dispute that defendant's statements were published and disseminated on her website and video and other forms of social media. There is genuine dispute of material fact whether all the statements that she made were in fact false and defamatory. So the court's saying, no, there are material fact differences and a jury is going to have to decide. Although plaintiff vehemently denies the information contained in the statements, defendant has represented to the court through video evidence that plaintiff has at least admitted to being a prostitute and to her drug use. Right. And those can be contained in song lyrics too. I've had cases where we've used song lyrics of somebody speaking in the first person, the same way if somebody wrote a novel, or not a novel wouldn't work, wrote a biography saying this is things I've been through in my life, or gave interviews saying it. You can't say later, you shouldn't be repeating that if that person has said it. So the court is saying, no, there might be truth to that. So we can't just throw it out. For example, in a video produced in opposition to plaintiff's motion for summary judgment, it appears that plaintiff is discussing engaging in sexual acts for money. So it's not defamatory if you did it. In the same video, plaintiff discusses her use of drugs and having to pop pills sometimes when necessary. Though, I mean, I think there's probably more than that. But if it's just popping pills, those could be legitimate prescriptions. As to the other assertions, such as claiming plaintiff has herpes, defendant saw a photo that plaintiff posted online, which plaintiff has visible cold sores. Assuming, of course, that the testimony is admissible, because that's always a question, it's at least possible that a jury might believe that these alleged defamatory statements made by defendant are true. But a jury could also believe that she didn't have malice in it because this is a celebrity, saying she wasn't being malicious because of what she saw. So even if it is not specifically true, it's not a malicious statement because she had good reason to believe it was true. For the third element, it depends whether she's a public figure under New York Times versus Sullivan. We talk about that case a lot. There is no way that you're arguing that Cardi B is not a public figure. We're just moving on. Cardi B is a public figure. If Cardi B is not a public figure, no one's a public figure. Cardi B is a whole ass public figure. We don't need to discuss public figure anymore. In this case, plaintiff argues it does not matter whether plaintiff is a limited or all-purpose public figure because she's able to establish that defendant acted with actual malice. So even Cardi B's like, yeah, it doesn't matter, but she was malicious, which is the extra standard if somebody's a public figure. The court agrees the appropriate standard is actual malice because plaintiff is fucking famous. We already established that. To whether malice was here, you have to find she stated that the statements were, I just lost my train of thought. To whether Tasha K acted with actual malice, namely whether she published the statements with obvious reasons to doubt the veracity of the information or accuracy of her reports, presents several genuine disputes of material fact. A jury could find it either way, like we just said. There are some facts suggesting Tasha K may have posted and published statements without knowing if they were true. Also in that same call, so they go through the facts, but because a jury could also conclude that defendant's sources were reliable, the court finds that granting summary judgment on these claims is improper. So there's actual factual issues. Same with IIED, same with invasion of privacy, there's factual issues. But when it comes to the counterclaims, the court's like, no, there's no evidence there. The court grants plaintiff's motion for summary judgment as to the assault counterclaim, even viewed in light most favorable to defendant. The evidence is insufficient to support her claim. So no assault. IIED, intentional infliction of emotional distress. To survive summary judgment on IIED, plaintiff must show all four elements: intentional or reckless conduct, which is extreme and outrageous, caused emotional distress, and the emotional distress itself is severe. While physical impact is not required in its absence, a party speaking the assertion of IIED must show that the conduct in question was directed at her. Tasha K has failed to provide material evidence demonstrating that plaintiff's action caused her extreme emotional distress. Defendant Tasha K points to threats and intimidation from Cardi B fans as the main source of her emotional distress, yet there's no evidence that these actions were committed by Cardi B or directed by Cardi B. Thus, causation has not been established, and that is also getting denied. For the foregoing reasons, the motion for summary judgment is granted as to the assault and IIED claims. Consequently, the request for punitive damages and attorney's fees is also yeeted. Additionally, the motion for summary judgment is denied because there is that material issue of fact as to whether or not there will be enough truth for a jury to go, I mean, if you show me the picture, I could understand why you think it was true, or I could understand why you believe your sources. They are going to have factual hearings, in this case at trial, similar to the circus we saw with the Johnny Depp case. It's going to be an entire trial about whether or not Cardi B has herpes. So that's going to happen. That's going to happen. That is going to trial. We're going to continue to follow it as it gets to trial because it will be well, if it goes to trial, because the court did say to Tasha K's team, you probably want to settle this. Yes, there may be issues of fact, but you probably want to settle this because it's a lot of statements. And if Cardi B's team can prove that she knew that they were false, it will be interesting. But the court is saying a jury could go either way. So we'll see. This is set for trial. I said it earlier at the top of the stream, but this is set for trial in the fall. So this is set for trial soon. I'm looking for the date in this article because I forgot to write it down. But it'll be interesting for the YouTube community because this one might go the distance and actually go to trial. Trial is set for September 10th. So we will keep it in mind. It's going to be very, very interesting to see what happens because this is a celebrity suing a YouTuber over statements that may or may not be defamatory, and we will see. So yeah, y'all, that's what's going on there. We're still in, oh my God, we're over an hour in. The weekly roundup took so long this week because I was so interested by this. Diva views, I appreciate your sass. Look, y'all, there's no shame. There's no shame. There's no shame. We're not judging anyone's health. Why does everybody say it's like the worst thing in the world? Like Trisha Paytas freaked the fuck out when Gabby Hanna was blasting her sexual house status, not online, but to people that they both knew. Well, to Trisha's boyfriend at the time. It's just so interesting to me. So we'll see what happens. We're going to keep following it. Let's go ahead and close this poll and see what you guys think of, is 2.5 years too low? 88% said, yeah, that shit's way too low. Way too low. Ragdoll, if Cardi B is required to do a medical examination, would she drop the case? She's going to have to prove something. So we'll see. We'll see. We'll see. This is going to go to trial and a jury's going to have to decide. I mean, bringing in medical exams would be one way, but it's not that she has to prove that it's false. She has to prove also that Tasha K knew it was false and still acted maliciously. And that's the interesting quirk to defamation, in all things. All right. I'm going to check my court listener real quick. Why is my email? I told you there was stuff that was going to pop off, and my email is just like, so we'll get there in a minute. We are at 1 hour and 15 minutes in, and we still have to do Britney updates, and we have to do Girardi updates, and we have to do a quick Jen Shah update. So Jen Shah is coming up next. Let's talk about the government's response really quickly, because I am doing a deep dive on this case. So we're going to talk about it briefly because, well, I said I would. The government has responded to Jen Shah. Hold on. We need to swoop. The government has responded to Jen Shah's motion that statements that she gave to the, law enforcement officers have to be thrown out because her contacts were dry. There were some actual really interesting arguments in there about the theory of the case and the fraud theory of the case. Jen Shah is a Real Housewife of Salt Lake City. She has been indicted on 2 federal counts, wire fraud, and conspiracy to commit money laundering. They're arguing that the government didn't plead the case particularly enough. So how can they defend it? There's millions of documents. You've got to tell us what the fuck she did, which is an interesting argument. And we'll see what the court does on that. But they also said her statements to law enforcement have to be thrown out because, her contacts were dry and she couldn't understand her Miranda rights because her contacts were dry. Well, the government brought in her signatures. They argued a lot. The government very thoroughly responded to the fact that they don't need a bill of particulars, that the defense motion to dismiss the indictment shouldn't be granted. It shouldn't, and it won't be. The bill of particulars is like, hey, can you tell us exactly what you're saying that she did? That might be granted, which isn't detrimental in any way to the case. That they want to suppress the search warrants because information they're saying was left out. The government's saying, the stuff that wasn't in there is not material to the case, meaning it doesn't matter. A search warrant wouldn't get granted or not granted based on that information. You don't put everything you have in a search warrant. For disclosure of the grand jury minutes, that's probably not going to get granted by the court. They're not going to open that up. For disclosure of Brady and Giglio material about the co-defendant post-arrest statements, she wants to know what Stewart said after his arrest. You have to tell me what Stewart said after his arrest. That could be exculpatory to me. Turn it over. She hasn't gotten that yet. She wants to know what did Stewart say? Here's my guess. This is complete and pure speculation meant to be funny. I imagine what Stewart said is, I just do what she tells me to do. Somebody needs, like the clip from Real Housewives where he's like, oh, she just tells me what to do. I imagine that was his post-arrest statement. I don't know. I just do what she tells me to do. What we did learn in the defense motion, though, is that the FCC had investigated these companies before and had investigated Stewart and Jen Shah before this. To suppress the defendant's post-arrest statement, I don't think that's going to happen. And to file additional motions, we'll see. The government has said these motions are entirely without merit and should be denied. We know what the background is. We're not going to get into it because I'm going to do a deep dive because they have included more information on the scheme here. And that's going to be really interesting to dive into, but it is a deep dive into the scheme. This talks more about the FTC investigation. This talks more about other investigations. Names are redacted out because there's other people involved in this. They go through the defense argument. The thing I thought was the most interesting is that they included her signature. Oh, I will scroll without making you go through it, but they included her signed statements that she said she couldn't see. And I thought it was hilarious. I love the way they broke down this scheme. And I think maybe the court will go, well, you broke it down in this motion enough that we don't need a bill of particulars because you've made it make sense. But also with pleading more particularly, it protects Jen Shah from being prosecuted from other acts at other times down the road. And I don't think that that is completely unreasonable. I just don't. The rest of it's not going to fly. And we'll deep dive into this. There is a lot more information in the government's motion. I've been promising a deep dive forever. I know I have. Department of Homeland Security Statement of Rights. This is her signature. She said she couldn't see it. They read these aloud to you. Before we ask you any questions, it's my duty to advise you of your rights. They read this out loud. They record you while they read it out loud. You have the right to remain silent. Do you understand? Okay, sign here. Anything you say can and will be used against you in a court of law or other proceedings. Do you understand and waive your right? Yes. Okay. Initial here. You have the right to consult an attorney before making any statements or answering any questions. Do you understand? Yes. Okay. Sign here. This is where she said she signed on the wrong line. Look, she signed at the end of the line. It's not the wrong line. It's just the end of the line. What? You have the right to have an attorney present with you during questioning. Do you understand and waive your right? Yes. Okay. Sign here. If you cannot afford an attorney, one will be appointed for you before any questioning if you wish. Do you understand? Yes. Okay. Sign here. Look, when you're signing these, just FYI, it means you are waiving your Fifth Amendment rights against self-incrimination. You're saying, no, I'll talk to you. Let's have a chit chat. That's never going to go well. That's never going to go well. Let your lawyer have the chitty chat. If you decide to answer questions now, you will still have a right to stop the questioning at any time or to stop the questioning for the purpose of consulting an attorney. If shit gets hot, you can say, now I want my lawyer. I am asking for a lawyer. I cannot go any further without a lawyer. Do you understand that you have the right to stop us asking you questions? Do you waive that right? Yes, I do. I understand. Let's talk about it. And then she signed down here and dated. She couldn't see it, y'all. She couldn't see it. She couldn't see it. She couldn't see it. She couldn't see it. Like, what? Emma C said she really said, I'm sorry, I can't hear you. My eyes are dry. Yes. That's why she wants all of her statements thrown out. That is not going to fly. It's the most entertaining part of all of this. A deep dive is coming in the podcast because we learn a lot more about this business opportunity scheme, but that's literally at least a 1 hour discussion. I mean, it's long and we have other stuff to get to. We do. Oh gosh, we have other stuff to get to. All right, I want to do quick Britney updates because we have other stuff. What is happening? As my phone keeps like blowing up about shit. Because I have alerts that are blowing up about shit. Let me pull up Britney stuff. Sorry for the pause. My brain. There's a lot of cases tonight. Wait, did I say we were going to do Girardi next? I think I did. Wait, I was going to tell you a DA story. Okay, DA story. That's what we're going to do. We're going to do DA story. That's what I said. So there was this judge. California has a 3 strikes law. And in the California 3 strikes law, the way that it was imposed when I was a DA, because not all DA's offices do it the same way, but the LA County DA's office, under the 3rd strikes law, at the time that I was working as a DA, things have since changed. There's new policies. If you got strike offenses, which were generally very serious offenses, if you got strike offenses, then after your 3rd strike, it's a life offense. Now, there are some ways that you would have 2 strike offenses and then have some bullshit little offense, and then that would be a life offense. But the LADA's office under DA coolly decided not to do it, that the only time you would get life is after actually 3 strikes, not after 2 strikes and then stealing a piece of pizza, because it seemed like a miscarriage of justice. So there would be 3 strikes. This judge, when people would plead to strike offenses, he would put down the plea form and you would advise defendants of their rights. You would read out the agreement and you would tell them what they're pleading for because they're choosing to do it. It's not that they've been found guilty. They're choosing to plead to a strike offense. Their defense attorney would tell them all the things. They're entering into a plea and the judge would be like, but strikes are like herpes. They never go away. They may lay low and they may lay low for a period of time, but if you do something else, they're going to flare back up. They're going to flare back up and increase your sentences. They're never going to go away. They're always going to be there. You might not remember that they're there. It doesn't matter. They are going to flare back up on you if you do something else. Those strikes are going to flare back up. And after being in this courtroom for long enough, I could not take pleas on serious fucking cases with regard to strikes because I knew it was coming. Like I knew the herpes conversation was coming and I was just sitting there going, oh my God, oh my God, oh my God. Here we go. We're going at the herp. We're into the herpes conversation. Okay, don't laugh. Don't laugh. Just sit there. And I would sit there and just be like, okay. This is serious. Like these are serious offenses. Like, okay. We're just gonna breathe. We're not gonna, it's not funny. It makes sense. Like it's a way people can understand it. Kristen, it's exactly right. Kristen said it's actually a good analogy. It is a good analogy. But it's also the dramatics of it. These strikes will flare back up. You do something down the road, there it is. Strike offenses. They may be there 15 years and boom, in your face. And it just, yes, it's a good analogy. No, strikes cannot be expunged in California. Strike offenses are strike offenses. Sometimes you don't always find them until later. And then you're like, there they are. But yes, strike offenses multiply the sentencing. How many times did he give that speech? I mean, I heard it hundreds of times because you take so many pleas and the court was very busy and shit was very serious. So yeah, hundreds and hundreds and hundreds and hundreds and hundreds and hundreds of times. But that judge would always tell the defendants, it's going to flare back up. It's going to flare back up. So, the gift that keeps on giving. And I think the defense attorneys would probably warn the defendant that speech was coming because every single time, without a beat, the judge would tell the defendant that was coming. All right, let's get into who did we say we were talking about next? Jen Shah can't listen to her rights because her eyes are dry. And we've got to get to Girardi and Britney. Girardi first, then Britney. Girardi first, then Britney. I think Girardi first, then Britney. Oh, those are my notes. We don't need my notes. I think Girardi first, then Britney. Yeah, I think so. There's a bunch of stuff happening in Girardi. Let me pull up my other stuff because I have to keep switching because otherwise my computer has been giving me fan issues, right? So let us get to the Girardi stuff. First of all, there's some lawyery things happening. Oh, I need to swoop. Sorry, y'all. I need to swoop for the timestamp. Ready? We're going to take a big sip of water. And we're going to get into Girardi stuff. There's a bunch. A bunch of Girardi stuff. First things first. There's still other cases happening with regard to all of this. And the Illinois judge that originally kind of started all of this by freezing assets and holding contempt hearings is not done yet. The judge overseeing the Lion Air cases that were kind of the beginning with Edelson PC, the local counsel in that case suing and all of that stuff, those were the beginning of all of this. And at the beginning of all of this, the court held a contempt hearing, froze Girardi's assets, and then literally everything tumbled. I know that the attorneys from Edelson PC have given interviews on podcasts talking about Erica's filing for divorce, kind of triggering them that they were worried that the money was gone. Like if she's out, are we like racing against time to get off of a sinking ship? The judge there really wanted to know what the other attorneys at the firm were up to and why the defendants didn't get paid. David Lira and Keith Griffin are those two attorneys that are still going through the process. The bankruptcy stop. Once you go into bankruptcy, Michael Scott, bankruptcy! Once you get into bankruptcy, everything stops with regard to the people in bankruptcy. But all the other shit keeps going. So the stuff with regard to David Lira and Keith Griffin, who are, one of them is Girardi's son-in-law, the other was a prior attorney at the firm, they are still on the hook with this Edelson PC suit and all the stuff going on in Illinois. Well, the judge there literally yesterday ruled that the contempt hearing with regard to those two attorneys can continue to move forward. The judge is like, we're not pausing this for the bankruptcy. And the attorneys were arguing, but if you're holding us in contempt, we don't have access to the financial records of the firm. We literally don't know why these clients didn't get paid. We're horrified that they didn't get paid. And we can't defend ourselves, essentially, because we don't know where the money went either. And that's their argument. And the judge was like, y'all figure it out. We're going to go to a contempt hearing. So there will be a contempt hearing in September with regard to those two attorneys and why they didn't do their duty to make sure these plaintiffs got paid. I hope that we'll start to learn a little bit more about what was going on at Girardi Cases, the law firm, because I imagine that these two attorneys are going to go, this is what Girardi was doing. We don't have access to the books. We don't know. I imagine that's going to be their defense. So that's very interesting to me that contempt proceeding is still moving along, and we might see what the other attorneys at the firm were up to during this period of time. It's like a cutscene in the movie, and it's like, and over here, this is what was happening. I'm looking forward to seeing what information comes out of that. I imagine this is very stressful for all involved, but Edelson PC's like, you didn't pay us and you didn't pay all these clients. Where is it? It's $2 million. Like, in the grand scheme of everything we've seen, why couldn't $2 million get paid? Those attorneys declined to comment when asked for comment. One of the attorneys for the attorney said, Mr. Griffin is devastated and is similarly angered that the clients have not been paid their settlement money as required by the court order. Mr. Griffin spent months. Oh my God, my cat just scared the crap out of me because I didn't know he came in. You scared me, Fred. You saw the genuine shot. I was like, what is touching my legs? Where did you go? All right. Well, nobody can see you down there, so nobody knows that you're here. Come on. You can do that. Fred's like, we need a Fred break. Go ahead. Come on. Hello, Pawnard. Welcome. You just want to get to the other side of the desk and play with the Kleenex. Fair enough. He scared the crap out of me. What was I saying? I completely lost my train of thought. Oh, heart attack time. The court said that, oh no, Mr. Griffin's statement. Mr. Griffin spent months and months trying to get Girardi to complete his promises and obligations to the clients in the court. However, holding Griffin personally responsible for civil contempt is not appropriate based on the above facts. I want to know what he knew. Like, what was he trying to do to get these clients paid? I want to know. I would love to hear that. So that's what's going on with regard to the cases that are ongoing in Illinois with Edelson PC, with the Lion Air crash, and with the other members or former members now of the Girardi Cases firm. In other news, Erica Girardi got some new lawyers, which doesn't surprise me really, after her other lawyers, if you'll remember, her other lawyers tried to fire her as a client and went to the court and was like, we can no longer work together. We're out. And then they were like, no, just kidding. The relationship has been fixed. We're back. But now new counsel in both cases filed on the 5th of July a substitution of attorney form saying, hey, in this bankruptcy case, me, Evan Borhe of Greenberg and Goss, or Gross, yeah, that's Gross, is substituting in. And this is the former attorney saying, yep, we're cool with it. Go ahead. Enjoy. It's all yours. So Erica has attorneys that have substituted in for her on the bankruptcy case, which happened earlier this week. Can we believe that we're still the week after the 4th of July? Like, I cannot believe it. We are looking for a response from Ron Richards because I had pulled the agreement where they all stipulated to later times and then completely forgot that I had pulled it because the original date that was due was the 2nd of July and then it got pushed. I think I even talked about it on video and then completely forgot that I had talked about it. That got pushed to July 16th. So next week, that should be filed before the end of the stream. And we will see if that happens. And then the bankruptcy stay was lifted with regards to some of the victims in the personal bankruptcy case of Tom Girardi. This is the Gomez family. They are owed $11 million by Tom Girardi. They attached his personal assets, his home, and all that. They got a judgment lien against Tom Girardi and his assets. They have been in court trying to subpoena Erica before the bankruptcy started. And we saw clips of a deposition they did with Tom Girardi in The Housewife and The Hustler. Now the court has lifted the bankruptcy stay that stops all the other actions, stops the action they had going on in state court to try to execute the judgment, try to get the money back. They had an $11 million judgment. They're entitled to that money and they're trying to get it. But in a bankruptcy stay, everything connected to this stops. The judge said, no, we will lift the stay for one limited purpose, which is identifying recoverable assets and gathering information that will lead to other recoverable assets. They can continue to figure out where the money went and what money Erica has. All assets identified by the Gomez family shall be subject to all rights of the Girardi bankruptcy estate and the law firm Girardi Cases bankruptcy estate, which parties shall meet and confer in good faith to determine the character and ownership of the assets. So the bankruptcy judge said, yes, you can continue to try to find assets, but when you find assets, you have to turn over your work to the class, where the group has to then decide what happens to those assets. So it's not that the Gomez family can go find assets and then be like, we're good, bye. They have to come back and then resolve it with the two bankruptcy trustees for Girardi Cases and for Tom Girardi personally. The hope here, I think, is that state court will move a bit faster because they've been doing this and they were at the point where they were subpoenaing Erica to find out this information and should be able to get that to happen much quicker than in the bankruptcy court to try to get back those monies. And that's really what's happening with that stay. It allows them to continue on the process that they were already on with regard to Erica. So this was filed in court on the 6th. I know there stuff was popping in this court and stuff was popping in the other one all at the same time. So this was an order to approve a stipulation between the trustee and secured creditors for relief from bankruptcy stay. So this is an agreement that was made. The judge memorialized it. The other bankruptcy trustee had objected. The court approved it and said, you know what? Keep going. We're trying to find these assets. If you're going to take the time to continue on the case you're on, you're allowed to do so. So the motion is granted, the stipulation's approved, the automatic stay is lifted to identify the assets, elicit information that would lead to assets, and renewing the ORAP liens, if any exist, which are the liens they put on assets. And then to the extent avoidance actions are required, such actions shall only be commenced by this court. So some of the rights are still retained by the bankruptcy court, but they can continue investigating it. The Gomez family, the Girardi trustee, and the Girardi Cases trustee shall cooperate with each other with the collection efforts against Erica and third-party transferees, anyone else who got money, but, mostly Erica. And wow, okay, hi. I heard that. Including but not limited to the scheduling of examinations, providing transcripts of examinations, and providing access to related procured documents. Y'all gonna have to work together and turn over your work for the group project. So now this is a group project between the bankruptcy trustee for Tom Girardi, the bankruptcy trustee for Girardi Cases, the counsel hired by the bankruptcy trustee for Tom Girardi, which is Boris Trazion from Axe, the attorney hired by the bankruptcy trustee for Girardi Cases, which at the time is Ron Richards. We'll see if he stays on the case. There's a motion pending. And the Gomez family and their attorneys. Y'all gonna have to work together to find these assets. That's what that lift of stay is, to try to track down this money before really it's gone, is I think what the hope is here. Fred's just gonna make himself comfortable on the desk. He's like, it's nice and cool. So that's kind of a brief update of what was happening in the Girardi case. Are you guys ready to talk about Britney? Let me know if you're ready to talk about Britney, and we will get to that in just a second. Question, now that we all know that Erica filed for divorce November 3rd, when did the Illinois judge bring all this to everyone's attention? Oh, I'd have to go back in my things. Hold on, no, it might be right here. That's a good question. The Edelson PC suit was filed after that because her divorce was part of what prompted it. And I have it in... Let's see what file I have it in. I have it in my file because now I'm curious. let me find it. But the Edelson PC case was filed right after that because that's the case that alleged that the divorce was a sham. So that's where that came from in the Lion Air case. Let me see where I have the original. Let me see. That was filed on 12/2/2020 is when the complaint was filed. So a month, almost a month after the divorce was filed, that's when it was done. So that is a great question. Thank you for asking it. So thank you. It's time to get to Britney. It's time to Britney. There are so many Britney motions. It's time. I just closed I can't put up a poll because I just closed it, but we'll put up a poll in a minute. We don't need it right now. We've got a whole bunch of Britney motions to get to because new stuff has been popping off left and right. As expected, the judge has pushed. Oh, I should swoop. Oh, we're gonna swoop. It's Britney. It's Britney time. There have been a bunch of motions. There have been objections by Britney's dad. There is a whole fuck ton of stuff happening in the Britney Spears conservatorship case. I'm going to pull up all my documents and we're going to get to it. As anticipated, the judge today has pushed more of these motions onto July 14th. So everything that's happening right now in court has been shoved to July 14th. The things that we are tracking right now with regard to Britney are Britney's mom's motion for Britney to be allowed to hire private counsel. Britney's mom said, let Britney hire her own attorney. I'm petitioning the court to allow that to happen without an examination. The court said, cool. We'll talk about it on the 14th. Britney's conservator of the person, temporary, Jody Montgomery filed two motions. Jody Montgomery said, I would like to appoint a guardian ad litem. Well, I would like the court to appoint a guardian ad litem to help Britney hire private counsel. She doesn't need an examination. The guardian ad litem can work with her on this. It's somebody not connected to this case. And I would like to be allowed the court to follow this procedure. Britney wants private counsel. I can't guide her on hiring private counsel. Someone else needs to help guide her in this. And right now, her attorney is trying to bounce. The court said, good. We'll hear that on the 14th. Britney's attorney is trying to resign. And the court said, good. We'll hear it on the 14th. Jody Montgomery also filed a motion with regard to security fees saying, hey, shit's gotten wild. Can you please approve the estate of Britney Spears, the conservatorship estate, paying for personal security with regard to all of this? And in that motion, I'm going to pull it up because Dad Spears objected to the motion. And the objection and the motion don't jive with each other, which is very interesting. So let me pull up Jody Montgomery's motion real quick. And the court said, what did the court say? Cool. Let's hear this on the 14th. So Dad Spears also objected to the appointment of a guardian ad litem. We'll get to that in a minute too. We're going to pull up the motions and then pull up the objections. So here's the ex parte motion from her. This is Jody Montgomery's motion to cover the expenses with regard to the threats that are happening. We already went through this motion pretty thoroughly, and that is in the breakdown on the channel, and it's in the Britney Spears playlist. I believe it's the last time we talked about Britney that was going on. There are texts from Britney saying, I still want you to be on this case. And then there's emails between Jody and everybody else. So this is the security professionals saying at 14 days, it's going to be $25,000. It's a lot of money. It's armed guards. But this is the interesting thing. This is from one of the attorneys for Dad Spears. And it's, hey, Vipe, good to see you. And it's saying, Jody, just want to give you a quick update since my prior email. Your safety is of paramount importance. And in reviewing your request, it wasn't clear to me if you had notified law enforcement. If so, please do. Second, Jamie has approved hiring additional security effective immediately. Let me know when they arrive. Third, Jamie has requested a meeting with Sam and Bessemer to alert them to your concerns. Fourth, Jamie has requested that we put together a risk assessment analysis promptly, inclusive of implementation of recommended protocols. Lastly, Jamie has requested that appropriate court approvals be obtained as expeditiously as possible. hey, we're going to approve it, but we also want the court to approve it because we don't want the court to come back later and say, why'd you approve this expense? Because all these expenses do go through the court. So, hey, get it approved. That's not what Dad Spears says in his motion. Dad Spears in his motion says, oh, we don't want to pay for that. So the email is saying, we're all good, just get court approval. And then the objection was like, yeah, no, we didn't say that. So Dad Spears files this motion to the court opposing the petition for instructing the conservators of the estate to pay for additional security expenses. Literally, what the fuck? The court should deny the petition because such an expense is not reasonable, necessary, or proper. What? Your attorney said, we're going to approve it, but could you get court approval, which is appropriate. Get the court to say that it's okay. And then he objects going, we're not going to do that. Literally, what the fuck? Let's look at the dates on these. This is literally the date, July 8th. Let me pull up the date of that email real quick. I'm going to just do them side by side because I don't want to have to keep putting them back and then pulling them back up again. So let me just pull it up because it's like literally a day or two has gone by from, we've approved it. They should be there soon. Please ask the court for approval quickly. And we're not doing that. It seems like a really big turnabout on a fairly serious topic. And I don't understand. It's like, what in the manipulation is going on here? And I don't understand why this is the play. Like, why is it the play to fuck with somebody over this when he's paying for his security through the estate too? This email was sent June 30th. So June 30th, your safety is of paramount importance. And it's, talk to law enforcement. We're approving it. They should be there now. Let us know. We're approving it effective immediately. That's on literally June 30th. July 8th is, we don't think any of this is necessary. Mr. Spears is very concerned about the situation that has been developing for many months and the dangerous rhetoric that has been circulating for quite some time regarding the conservatorship. Dad Spears is aware of the increasing number of threatening communications and social media posts directed at various individuals of the conservatorship, apparently including Miss Montgomery now. Spears himself has been the subject of innumerable and ongoing threats, but for years. I've been dealing with this for years. So Mr. Spears understands well the challenges inherent to the position he holds and the work he performs on behalf of his daughter. We know how hard it is because we've been doing this for years. Welcome to the big show, sweetie. Man up. That is what this is saying to me. And it's just annoying the shit out of me. However, Spears disagrees and objects to the request for 24/7 live security for herself at the cost of the conservatorship. The court should consider additional factors beyond what she's alleged. So the court's like, yeah, we're going to set this all over for hearing. Mr. Spears is informed and believes that the Conservatives' court-appointed counsel, Ingham, has received threatening communications, including receiving 2 very threatening voicemails just this weekend. Spears himself and his attorneys have received similar threatening communications, including threats of violence and death, for some time. The court therefore needs to know that Ms. Montgomery is not the only person who might seek additional protection paid by the estate. Based on the estimate provided, the court of the conservatorship estate live security service could exceed $50,000 per month. The court should consider how much security is truly necessary. Here's the thing. At the end of it, at the end of all of this, what he had said was, it is not appropriate for Mr. Spears to be put in the position of picking and choosing among who of the many individuals impacted by the conservatorship should be permitted to charge the expense of live security services to the estate. As a licensed professional fiduciary, Ms. Montgomery should pay for any security services personally as a cost of doing business. What? First of all, I agree that there should probably be parameters and the court should look into the severity of the threats. But the security company that Jamie referred to Jody Montgomery based on these documents said, this is our assessment of what you need. It wasn't Jody Montgomery going, this is what I must have. The security company said, we've assessed the threat and this is what you need for now. The fuckery on this is just so wild. And the like, oh yeah, we're cool, we're going to do it. I am changing the lights. I'm changing the lights. The security of, oh, we're doing it, it's fine. And then the turnabout of, oh no, we're not going to do it. No, we're not going to do it. No, we're not going to do it. This is not all the way red. There we go. It's just... My phone fell. He's running PR expenses through the conservatorship. What? This objection. And the court's like, we're going to do it on the 14th. Okay, thanks, bye. The next motion that he objected to is the appointing of the guardian ad litem, which is a motion I quite like. I know not everybody likes it. That's totally fine. I think it's a good plan. I think it's a way to get an independent attorney to do nothing but help Britney hire an attorney. So the guardian ad litem would be a limited purpose just to help Britney hire her own counsel now that her counsel is trying to quit. I think that that's a good thing. I see it as a way to get her somebody outside of the group that has been dealing with this for 13 years and give her someone who might be there just for her. And his objection, let me find it within all of these objections because there's a lot of them. And they got a little out of order. My apologies. That's the estate. This is it. So, James Dad Spears' response to temporary conservator of the person Jody Montgomery's ex-party petition for an appointment of a guardian ad litem. The ex-party petition should be heard along with related matters on the 14th. And that's exactly what the court did. The ex-party petition raises complex factual and legal issues that require additional notice and briefing. Did I not say that that's exactly what they were going to say? They were going to say it to Mom Spears too. No, we need additional briefing. No, we need additional this. We need more time, including, among others, the facts and circumstances that support the appointment of a guardian ad litem for Ms. Spears and the structure mechanism that will be used by the court to determine whether the appointment is appropriate. Britney said she wants private counsel. Britney said she doesn't want to be evaluated again. Britney's lawyer said he would help her do that, and then he is trying to quit. Who else is going to help her do it? It's a conflict of interest for her dad to do it. It's a conflict of interest for her guardian ad litem to do it, and her court-appointed attorney is trying to bail. Who else is going to do it? Who? Who let the dogs out? Who? That's how I feel. Who else can help her hire an attorney? She's not going to be allowed to do it herself. The guardian ad litem wouldn't have a capacity argument to say they don't have capacity to do it. And if you don't want to do that, appoint Lynn Spears as attorneys to do it. Let them do it. Oh, this is so frustrating. So the argument is we need additional briefing. Further, the issue raised by the ex-party petition implicates and relates to other matters already pending on the 14th. Well, true, including the application for appointment of counsel filed by court-appointed attorney Sam Ingham. What the court could do is say, you know what? Sam Ingham's asking for court-appointed counsel to represent Britney as her attorney. Jody Montgomery's asking for a guardian ad litem. We're going to appoint a guardian ad litem and let her hire private counsel because her mom also petitioned for private counsel. That just makes the most sense. And that's the only thing that's going to get done on the 14th. And then everything's going to get put over like 6 months for that attorney to get up to speed. It's just a mess. Here's how I feel about the motion with regard to the security. I think Dad Spears is trying to scare off Jody Montgomery. I think he's trying to make sure that she will leave because she's afraid. And that is a big concern if she does that, because if she leaves because she's afraid, who is going to be there asking for these things to be done? I don't know. So it is concerning to me. It's a lot concerning to me. And we need additional briefing. We already see where this is going. On the 14th, they're going to look at the judge and be like, well, Your Honor, we can't possibly make these decisions today. We need additional briefing. Britney's supposed to appear at the hearing on the 14th. Everyone has put in notices of remote appearance according to the court docket. So you see the argument being set up now. Well, we can't possibly go forward. We need briefing. Put it over for 6 months. I think he's trying to get space from the court hearing. This is my supposition. Trying to get space from the court hearing to distance further the people who are there trying to get Britney the thing that she wants, which is away from her dad and private counsel. I just don't know how it's going to go, and I'm just very, very frustrated with it. I'm going to check this notice that I got because it's interesting, and it looks interesting to me, so give me 1 second as I check this. I've been following a couple cases because of other things that are happening, and it looks like there's I put it in wrong. It looks like there's a new notification. And I want to see if I can pull up the documents easily and quickly. And if I can't, then I won't. Let me do this real quick. And if I can't, I won't. And the mods are like, don't do that. Please don't do that. Please don't. Please don't do it. Oh, I got logged out. That's so annoying. All right, I'll log back in a second. But we're going to go to questions. I'm going to continue to look for that because it's hard for me to process information that comes across while we're here. River said, yeah, but he doesn't want anyone to help Britney with getting an attorney. That's right. It seems like he doesn't. That's my opinion. It feels like he doesn't. He argued again that he argued when Bessemer was getting appointed that they shouldn't be given full access as a co-conservator. He seems to me has been grabbing at control as much as he can. We're moving into questions, so let's just move into questions. So let's just move into questions. I'll try to find that on the side, but it's time for questions. It's been a busy one. Oh my God, we're almost 2 hours in. It is so frustrating. Question, can you check the filing from Jody today as TMZ is reporting? I didn't see a new filing from Jody today. Let me look at what TMZ is saying. It might be the ones that we've already covered. I see, here, I'll just pull up what I see. I don't always love the way TMZ reports things. Gloves comes off in conservatorship battle. Jody rips into Jamie. Britney Spears has a front row seat for a battle royale between her father and her personal conservator, Jody, who's firing back. Montgomery filed docs Friday, blasting the dad for attempting to lay blame at her feet for Britney's brutal treatment. Jody says it's ironic that Mr. Spears now wants the conservatorship to reflect her wishes, since it's no secret that Mr. Spears has wished her father out of her life for years. As for Jamie, in a previous filing that Jody or others have prevented him from communicating with Britney, Jody writes, Miss Spears is the one who cut him off. That was her choice, not Miss Montgomery's. According to the docs, Jody also says it's absurd for Jamie to suggest she's making decisions without him. Let me pull it up because I have like multiple court alerts going off. So let me pull that up real quick. The mods are like, no, don't. Yes, do. Yes, do. And I haven't been able to go through all of the alerts on my email. So let's pull this up because these things do populate late for me because this is West Coast. So as per TMZ, Jody just ripped Jamie a new one. Well, it probably popped up because when I was prepping for it, nothing was there. So it must have popped up. And it's probably one of the things that I am getting pinged about. So let me let the court system work and see. Hold on. Question. Will we even know what happens on the 14th, assuming everything's going to be sealed? I don't know. If they allow people to report on the hearing, then you might have reporters in the room that respond, that actually attend. If it's sealed, we might not know much. So let's see what documents have been filed. Supplement number 2 to fee petition was filed today. Notice of appearance, notice of hearing. I am not seeing anything new filed by her, but let me pull this up because I'm only seeing a supplement to the fee petition. And unless she's slamming him in the supplement to the fee petition, but let me pull that up and see what it is because that one wasn't there earlier. This case has been moving so fast. Question from Yamino Gaming. Will you cover the Ace family lawsuits? Yes, I will. I don't have the documents yet, so I have not pulled them up yet. I've got the ex parte order. I've got the notice of hearing. I've got the James Spears opposition. It's just this supplement to fee petition that I don't have. And this one. All right, let me pull those up. They'll have to be emailed to me and we will see. It's just so much stuff. Question. Hello from Australia. This is Zero Shade. I love Britney. Who is responsible for her hair? Seems that they can spend so much money on their PR. She should. Well, yes, but they're not allowing her to. And she complained about that in court, that she has not been allowed to have her personal care team. Some of that's due to COVID lockdowns in California, because COVID lockdowns weren't allowing anything to be done for quite a long time. But yes, it seems like she should be allowed to take care of herself. And she did complain about that in court. So, yep. Just like a circus, why is everyone giving her dad so much power but ignoring all this obvious buffoonery? Because he's the one in control of the money right now. And they're going to have to try to wrest that control from him. And they've been chipping away at it by giving Bessemer co-equal powers, and Bessemer's trying to bail, which is why I'm frustrated. Bessemer's trying to bail. WWE main event, JM versus JS cage match. I mean, I'm kind of living for Jody Montgomery being like, no, fuck this. We're not doing this. This is ridiculous. I'm here for it, for sure. So let's pull up these new filings and see what is said. These are all just notice of hearings. This is from Jody Montgomery. So let me save this and pull this one up. Supplement 2 to petition for order allowing and approving payment of compensation to temporary conservator of the person and her attorneys. Okay, so this is a fee petition. Let me go ahead and save this real quick so I can pull it up. Then I've got to be able to pull it up on screen, so it's got to go in the thing. Oh, it's so much stuff, you guys. I'm here for it, but this case is moving fast. Like fast. So, question, is there any benefit to the ACLU becoming involved if Britney could find any way to connect with them? I don't know if they would have standing at this point. Britney needs someone who can help her hire an attorney, and the court would have to allow that to happen. And it seems that Dad Spears is trying to object to that happening. Well, or at least put it over till the 14th. So someone needs to help Britney hire counsel. That seems to be the only way forward. It should be that Sam Ingham helped, but maybe it's better to have a third party who's not involved in this at all. Question, could Jody or I'm not familiar with Wendy Williams's video. So Jody Montgomery, when she talked about the death threats, said that she would provide those to the court to take a look at. So if whatever there is, the court can ask for that with regard to spending these fees. Let me see. A question, if God forbid something happens to Jody before the security matter is settled, could she sue? Tammy, that's a really hard answer because there's not an obligation. But I wonder if she has security right now and they're just fighting over whether she's going to foot the bill for this down the road, because the attorney said, hey, we're giving it to you. So, and they should be there now. So we'll see what happens with that. I'm going to go back and sweep for super chats in just a minute. Taz, I missed this one. I'm sorry. Dad Spears says he has Britney's best interest, but anytime anyone wants to do anything to help Britney, he tries to stop them. And Delta Saves has the reasons why. Follow the money. Follow the money. He is making so much money off of this estate that it's really, really difficult to see that he could want this to end, because this is his sole livelihood. Question, if Britney has requested to terminate the conservatorship, which she did quite publicly at the last hearing, how long can Sam get away with not filing it? Sam cannot file it. He's petitioned to resign. He's not going to file it now. And with him petitioning to resign, it's going to take a while for a new attorney to get up to speed to even make that motion to determine if it's in Britney's best interest or not. She can say, I want you to terminate this. And he can say that's not in your best interest, which is kind of the fucked thing about all of this. Can the Britney judge be recalled or have someone run against her? I don't know when she's up for election. It would be difficult. And it wouldn't necessarily put somebody different in that seat because she's a probate judge. So the person running against her wouldn't, that's not quite how that works. The person running against her wouldn't necessarily go into her exact probate seat. So if Jody M gets scared off, does Dad Spears get control of the person? They would have to appoint somebody new of the person. And we don't know who it will be. It's clear they don't want it to be Dad Spears, but because he's the conservator of the estate, it would be easiest to make it Dad Spears, which is concerning. So, Jody Montgomery, supplement number 2 to petition for order allowing and approving payment of compensation to temporary conservator of the person and her attorneys. All right, let's just get into the shade here. Thank you, mods. I know if some of you have to go that we're running long. I appreciate you. And we will do this real quick. As quick as we can. Conservator of the person of Britney Jean Spears respectfully presents her supplement number 2 to her petition for order allowing and approving payment of compensation. RE JTDs 2, 4, and 6. Note Bessemer Trust petition to resign elsewhere on calendar. And note that no LTRs of estate have yet issued to Bessemer. These are letters of conservatorship. Petitioner amends the fee petition to reflect Bessemer's trust petition to resign as follows. So this is Jody Montgomery updating her fee petition, approving the fees incurred by temporary conservator in the amount of $221,000 for services rendered by her to the conservatorship from November 1st to February 28th, November 1st, 2019 to February 28th, 2021. Authorizing, instructing the currently serving conservator of the estate to pay temporary conservator Jody Montgomery outstanding fees for $44,000, approving fees to the attorneys for $65,000 from November 1st, 2019 through February 2021, authorizing and instructing the currently serving conservator of the estate to pay, confirming to the court's order, and that's it. There is nothing else I see filed, so I'm not quite sure exactly what TMZ is referring to because I don't see anything else filed here. I will refresh it one more time, but that's what I see is the fee assessment. Could the blatant switcheroo of Jody's security be helpful to Britney providing her dad is an incompetent and unfit conservator? I don't know. I don't know. I think there could be an argument saying, look, he's saying one thing and doing another. I think there's a strong argument to say, look, he's playing games with the money, or he's holding the money over people's heads, which is something that Britney said in court. Britain said, wait, Americans elect all judges. No, not all judges. It's fairly complex, but at the state level, most judges are elected at the state level. And as you move up, judges get appointed for life at different levels of court, appellate courts, Supreme Courts, state Supreme Courts, but at the kind of low, I hate to say lowest level because it feels like, but at the state level of courts, judges get elected and can be elected out of office. They can be reelected and they can be bounced. Question, do you have an opinion as to why the court has not ordered an independent financial audit and independent review of her care? They haven't been asked to do that until Dad Spears made the motion to do that. And I was optimistic Bessemer Trust would do that, but we're not seeing Bessemer Trust being willing to stay on here. So let me go look and see what TMZ said, because TMZ did not say which documents these were that were filed. So yes, they do say it's full on war. Yes, I think that we're going to definitely see them point it out. This is the motion we just read. Hey, judge, approve my $221,000 in fees. She should be getting paid. This is like a year of work. So I don't know what else. I don't know what this is about from 6:41 p.m. It might just not have populated in the court record yet. So if it populates over the weekend, I'll do a short on it. Otherwise, it'll push to Tuesday, and I'm sure it will populate. TMZ often has things sooner than I see them show up on the court website. But right now, there is nothing else on the court website. I have some notifications about other stuff. If stuff really pops off, we'll just do another live, because we've been live for over 2 hours tonight, and there will be more to cover. Galaxy S, this is, how do you prove conservatorship abuse? There's going to have to be an independent investigation. Here's the difficult thing. And I want nothing more than for Britney to feel safe, to feel heard, and to feel like she has autonomy of her life. But if there are things underlying this conservatorship to make some of these restrictions legally or medically appropriate, though it feels abusive to Britney and it looks abusive to the outside, it might not legally meet the standard because there could be justification. I have a lot of questions about it, but that is the other side of the legal argument. There is hope by me and others that if Bessemer stays on, they will at least be looking at how money's being spent and if there's been any fraud in that. So there are quite a lot of questions. Question, can Britney sue everyone before being released? She has to have an attorney to look into everything first, and there has to be grounds to sue everybody on. And I don't know what those would be yet. I just want to see what happens next. Like, trying to think through all the different avenues are difficult. But remember, the conservators have a fiduciary responsibility to do what is best for the estate. So for her dad's job is not to protect her per se, but to protect the estate. The conservator of her person is supposed to do what's right to protect Britney and to protect Britney's interests. The estate's to protect the financial interest. So proving fraud in that is going to be hard, showing, hey, how is this in the financial interest? Because every time there's expenditures, they go to the court and the court has to approve them. So if the court was just rubber stamping expenditures because Sam Ingham wasn't objecting to them, there's bigger questions there. Now we're seeing Britney's mom's lawyers objecting to stuff and saying, wait, whoa, why are you spending money on this? I don't agree, particularly with regard to the PR stuff. So if the attorneys just weren't active, is that fraudulent? No, because the court's still approving it. Is that strongly less than desirable? Yes. Could it be fraudulent with more information? Anything is possible. We just don't have that information. There are still so many questions in this that I'm trying to just break down the documents as they come. Looking forward, it is always my hope that the personal conservatorship starts to reduce in severity so Britney feels like she has a life, and that the financial conservatorship doesn't have her dad involved, and then go from there. That is my next step hope. How does one get a job like a conservator? There are different procedures in California, but I would have to look at exactly what's required because off the top of my head, I do not remember the requirements, though some of those are listed on the court website, but I just do not remember off the top of my head. So, could a new attorney petition to dismiss the whole case for not filing LP? What? You're going to have to tell me what you mean for LPS. So please tell me what you mean by LPS court. Question, could it be negligence if it's not fraud? Legal negligence is difficult too. Could it be? We don't know. And it's really hard for me to speculate because we just don't know what we don't know. So it's very hard for me to speculate on stuff like that. I don't like what I'm seeing either. I'm also aware that I'm not seeing everything. And I really try to parse these documents knowing that there's more I don't know. And if I knew everything that the judge knew, would I feel differently about it? I don't know. I don't know. And so it's hard for me to say, this is obviously this or that, because I don't have all the information and I try not to make judgments without all the information. I try to break it down and point out where the questions are and point out where the big questions are so we can start looking for the answers that are appropriate to answer some of those questions. Hopefully my process helps. Gary, we've talked about this quite a lot. And the question was, how's it legal for her not to choose her own attorney? Back in 2008, They found that she didn't have the ability or capacity to do so. Her mom is saying shit has changed. Let's allow it now. Can Britney sue California in federal court? People can refuse to take medicine. Why can't Britney control her money and make reproductive choices? Could she sue California for what the judge is doing? I would have to think on that. My gut response is I don't know what she would sue the state of California for. Failure to oversee? But it's being overseen in the process that it gets overseen. In a conservatorship, she doesn't really have the same rights that everybody else has, and that's the biggest problem here. So, yes, Spider asks, how does she still have the capacity to perform? And those are some of the biggest questions here. This is a whole lot, you guys. If there are more filings on this, I will keep you in the loop. There are other filings that I'm going to be looking into. I've got another podcast coming up for you next week with some deep dives. There's a lot going on. I very much appreciate you for being here. It is well over 2 hours tonight. We didn't even have time to get to court of public opinion, but we did get a Ponard. Where did Ponard go? I don't know where he went. Fred, where did you bail to? Fred's not even saying goodbye. He just left. Fred has left the chat. I think he trucked back out of the room. But we did get a Ponard sighting. We got a court story. It's just a lot of stuff. So it's a lot of stuff. It's a lot of stuff, and it makes me really sad. I can't. It's so much. It's just so much stuff. So a huge thank you to the mods. Thank you all for being here. Thank you for being law nerds. We have over 3,000 of you in the chat. Don't forget to do the YouTube things. Like, subscribe, follow me along on social. That's where I post these things more quickly. So on Instagram, on YouTube, not YouTube, we're on YouTube. On Instagram and on Twitter is where I kind of do things more quickly. It's been a lot. There was a lot to cover tonight. We got into, oh my goodness, we've gotten into so much. There will be more to come. These cases aren't slowing down. I appreciate all of you. If I missed any of your super chats, I apologize. I do try to get to them all. And then they come in and the chat jumps and I miss stuff. So I'm going to check real quick to make sure before we bounce out. G dash, we answered that. Oh my God, it's Dana. Hello. RBG never referred to lower courts as lower. She and her clerks referenced the number of the circuit court. She found it to be rude and elitist. Yeah. Calling them lower courts is generally what they're called, but it always feels weird calling them lower courts. So the state courts, it's not even the state courts because the appellate courts and the Supreme Courts are different, but the state trial level courts, the entry level courts. No, that sounds wrong too. The first level court, because even then it's not a circuit court. It is the first level court, but I appreciate that. Oh my God, it's Dana. Coding Roses said, why do I feel like Dad Spears is trying to keep a hold of as much control as possible? Yes. And that is everything. Thank you. Thank you. Thank you. I appreciate you all. We will see you around social media. Thank you for being a law nerd. I've already said that. Cheers. Happy Friday. We out. Take care. See you soon. Connect with me everywhere. I'm at the Emily D. Baker. If you guys want to join the text, just text Emily.com. If you want to join the channel, lawnerdsunite.com. Happy to have you. Support what we do here on the YouTube.